welcome everyone. Thank you for booking on to this pupillage advice panel. I just wanted to clarify that this is not a qualifying session, so you will not be credited for this event. It is a free event. The panel for this evening are: chairing is Laura Gold of King's Chambers, Ben Close, St. Philip's Chambers, Kate Bissett, Hart Square Chambers, Ruth Bala, Gow Square Chambers, Ross McKinnon Johnson, Apex Chambers, and Martin Nelson, Government Legal Department. I'd just like to say a big thank you to the panel for being here, especially so close to New Year's and Christmas. I know we're busy. And also some housekeeping. There's a Q&A function on the webinar, which we'd really appreciate it if you use. Please just leave questions on there and the panel will answer. Thank you very much, and I'll hand over to Laura.
Thank you very much, Alice. Yes, good evening, everybody, all 140 of you and a few more that are joining us now. This is, as has been said, the Pupillage Application Advice Panel, and we hope that it finds you ready and raring to go with your applications and with some useful questions. We've got some ideas of some topics that you might like to cover, but please do put your questions in the Q&A. I think you might be able to put them anonymously, but don't worry. In fact, I've just seen somebody's put a question in as an anonymous attendee, and we'll pick those up and try to answer as many as possible. Don't worry if you think the question is a daft one. That's why we've set up this evening, so you can ask all those questions that you were too concerned to ask perhaps when you're on mini pupillages or the like. So we'll just do some quick introductions. I'm Laura Gould. As Alice said, I'm a barrister at King's Chambers and I specialise in employment, commercial and sports law. I was called in 2009 and I did my pupillage down in London at what was 3 Sergeants Inn, now Sergeants Inn Chambers, before moving to King's Chambers in Manchester and essentially back home on a 3rd Six, and I practiced from there ever since. If I could ask Kate to introduce herself, please.
Good evening, everyone. My name is Kate Bissett. I went to bar school with Laura, which might be why I'm here tonight answering your questions. I am predominantly a criminal and coronial law barrister based in Leeds. I did my pupillage at what was then number 6 Chambers, which merged in 2015 to become Park Square Barristers, which is the largest set on the North Eastern Circuit. As well as practicing crime and coronial law, I sit as a coroner and as a fee-paid judge in the First Tier Tribunal.
Thank you very much. And Ruth, please could you introduce yourself?
Thank you. I'm Ruth Bala from Goth Square Chambers. I specialise in regulated lending law, act for banks and financial institutions, very specialist, which is the way I like it. Practice in London, have been doing it for about 14 years now. You're muted.
Sorry, I am. There we go. Of course. Ross, please could you introduce yourself as well?
Evening, my name's Ross. I'm at Apex Chambers in Cardiff, predominantly in crime and trying to move into regulatory at the moment. I'm in my first 6, about to get on my feet in, I think, 6 weeks' time, which is a terrifying realization. I was called in 2021 and started my pupillage a couple of weeks after.
And Martin.
I was called a depressing 10 years ago in 2011, and I've been with the Government Legal Department, as it previously was the Government Legal Service or the Treasury Solicitors Department, all the time since then, working with different departments, including Transport, Treasury, and now currently with the Foreign Office, where I've been doing litigation and advisory work and some bits of legislation.
And we're hoping also to be joined by Ben Close from St. Philip's Chambers, but I'm afraid we're having some technical issues with letting him in as a panellist at the moment that I'm sure Alice is working away in the background to get solved. So we hope that we've given you a good broad range of experience and levels of call on the panel this evening. Some of us applied more recently than others, and I believe a fair few of us are involved in our Chambers recruitment process, and obviously Martin will be able to speak from a different perspective. So if we start off, I can see some questions starting to come through on the Q&A, and if I can ask you to put them in there rather than in the chat function, that would be very helpful. Here's a question for Ruth, I think initially based on what she's just said on her introductions. Ruth, when you're applying to a Chambers with a broad range of practice areas, which I think I'm right to say your Chambers does have, is it detrimental to an applicant to specify interest in only some of the practice areas?
Thank you. I would say it's important to make sure you identify an area which is actually practiced in by the majority of people in the chambers. So although it looks as if we practice in a range of areas, in fact, most people just do one or two. It tends to be regulated lending or consumer regulatory. We also make reference on our website, which is quite common, to areas which a few members of chambers will practice in, such as health and safety, environmental law and licensing. And sometimes you get applications from people and they'll say in their cover letter, I've been determined to do licensing law all my life, and I believe Goth Square would be a brilliant fit for me. And when you read that letter, you think, well, only a couple of us do licensing, and the ones who do are at a much more senior level. If you actually look at the website profiles of individuals in the junior end of chambers, you would have seen that none of them actually do licensing. So what I'd say is be careful when you look at the website. We do say we are a specialist set on our homepage. So you can then go to the practice areas, see which all areas will be listed, which anyone practices in, but then look at the individual profiles, especially look at the junior members of chambers profiles. And if they're all doing one or two of those practice areas, then don't make out in your cover letters if you're interested exclusively in an area which doesn't really feature amongst most people's practices.
Thanks very much, Ruth. Kate, you're in a very large set, but you've always specialised in criminal work. What's your understanding of your chambers and perhaps others in Leeds? Is the expectation to apply for a specific practice area, or do you want people to do a more old-fashioned common law pupillage?
I think from our perspective, it very much depends on how specific we're talking. If you're interested in, importation of bananas from the EU, we can't help you with that. If you're interested more broadly in civil, but not sure what area within that, then I don't think that is a huge problem. For me, I'd been interested in all sorts of areas of law. I've always enjoyed crime because obviously it's the best area of law. But I did other things in my initial couple of years. I did employer's liability personal injury because that's what my pupil master did, and in those days you just did what your pupil supervisor did, and that was the way it went. And he took the bench 1 month after I got tenancy and bequeathed me all sorts of work that I had no clue how to do. So I think generally what my chambers as a large set tries to do is give a really clear indication on what they're after, because if it is a solely criminal pupillage, it will say that, and if it is mixed, then it will say that. But at the end of the day, you are a self-employed barrister, so once you start, if there's an area you want to move into, then that is possible as well. And you also don't know what you're going to love, because the theory of what you practice, even if you've seen it on many pupillages, might not be the same as doing it day in, day out. So I always had an interest in inquest law because my dad's a pathologist, and so I'd sort of grown up around that kind of work. And it wasn't really something which my chambers at the time did, but over the past 13 years since I joined, it has developed an inquest team. So I think I would say don't limit yourself to deciding there's only one thing for you, because pupillage places are harder to come by. But I don't think there's anything wrong in being more general and saying I don't want to touch family law with a barge pole, for example, or big topic areas. I just wouldn't pin your colours to the mast on a very niche area like Ruth says.
Yeah, and I think it can depend on a chamber's approach, and the headline for these discussions is always do your research. When people apply to my chambers to do crime, that's a very, very bad sign. We haven't done crime since before I was there, and that was plenty long enough ago. But my chambers, we recruit for specific pupillages, so it might be business and property, it might be public law and planning, or it might be common law. And so I think that's, as Kate's saying, it can be wide-ish, but you need to know what each chambers wants and tailor your application accordingly. How does it work in the government legal department, Martin? Do you just apply generally, or do you express interest in particular areas?
So you do tend to apply generally in the government legal department, especially if it's for a pupillage. There are some opportunities if you're already qualified to move into particular departments, but the GLD is very keen on keeping its lawyers quite generalised, partly because legal issues tend not to turn up and work in nice little boxes that says this is a landlord dispute or this is a issue of proportionality, or this is an issue of judicial review. And so the tendency tends to be that the GLS prefers to keep its lawyers very general and to move people around departments. So there tends to be one graduate process that you apply for, and then the civil service finds places to place you, but you will always end up doing public law and the core constitutional aspects of that, because that's the heart of the job.
And so in terms of actually completing an application process, Martin, would I expect you'd want someone to show some interest in public law? Can they express interest in other areas? Or if they said, I'm interested in criminal law, does that indicate maybe they should be in chambers instead of in the GLD?
So criminal law is probably the example where we don't do a huge amount, although there are some people in the Attorney General's department who do that. But normally we would think that if you were interested in criminal law, then maybe the CPS or somewhere like that would be a more appropriate place, because we're much more civil. We'd expect to see some significant interest in public law and in constitutional law. But that's once you've got through that, anything else can only benefit. I've seen people who have talked about their interest in international law or about environmental law. Part of the joy of the GLD is access to areas of law otherwise I'd be far too thick to try and have access to, and people seem to let me go through anyway through the GLS. So it's always useful to have that extra interest in those other areas.
That's great. Thank you so much. And thank you, Ben, for joining us. We're so sorry that we're having some technical difficulties letting you in there. Do you want to just give a quick introduction? We're only partway through the first question anyway.
Yeah, apologies for being late. I practice in crime and to a lesser extent regulatory work in Birmingham at St Philip's. And I've been asked to do this because I sit on the Pupillage committee there, and also on the Education and Training Committee as an elected member of the Bar Council.
Fantastic. Thanks so much for joining us, Ben. Slightly jumping ahead, but I just noticed a question that leads on from something Kate said. There was a question in the Q&A. If you do a pupillage in criminal, can you then take up a tenancy in civil? Now, that's probably quite broad practice. Certainly I started off in a predominantly clinical negligence pupillage and was really quite bad at it because I'd never really meant to do it, and I don't like not going to court all the time, but you don't know until you try. I had applied for employment and got to do what employment there was in chambers, but it was one of those situations where the website maybe didn't indicate quite the amount of work that I'd hoped there would be. And so I ended up moving into employment in a third six. And I would say, don't be afraid of doing a third six. Certainly I and many of my friends that ended up doing them ended up in a far more suitable practice area, location, whatever it might be for them, because when you go through pupillage, you find out what the job's actually like to a limited extent, and what you're good at and maybe what doesn't suit you quite so much. But in your sort of broader chambers, Kate, do you see that happening? You obviously started off with some PI and don't do that anymore. Do people switch completely?
They do. The answer is it depends on the chambers. So in my set, for example, we had someone join us from another set from a different part of the country. They had a criminal background and they wanted to practice civil. Well, the head of civil had a chat with them, looked at some work they'd done and decided whether they were going to, I don't mean let, because you're self-employed, you can accept whatever instructions you want, but whether they were prepared to market them as a civil barrister as well. Because what you don't want is to just say, look, we've trained this person very well in crime, we're absolutely confident of their abilities in crime, and now we're going to stick them in an intellectual property court, which we don't have any evidence they've ever even read a book on or done anything about. So yes, it is very possible. And what you find is that your practice develops over time because you become known for being particularly good at a certain thing that you might never have dreamed of before you'd started the practice. So, for example, I get a lot of vulnerable defendants because my experiences lend me in that direction. So I deal with a lot of mental health issues within crime and sort of sub-context of that. Well, I'd never have told you 10 years ago that that's where I was going to end up. So yes, it is possible to change, but what I would say is it's not ideal to set out for an area just with the intention of going on to something altogether different. If you're not at least interested in doing the area in question, it's probably not worth pinning your hopes to going in and then finding another passion within the unit. But yeah, once you're qualified, you're a self-employed barrister. If you want to set up, an area of law, I mean, Laura, you might be a good one for that, because sports law didn't used to be a big thing 10 years ago, and now I know your chambers is fairly big on it. So how did that happen?
Yeah, with the help of a team in chambers, actually, for people to be able to pass on work to each other in order to grow. And I think people don't realise that that is actually how it works in chambers. You might be an individual, but you do very much rely on the team. Ross, a question leading on from that is, when choosing a practice area, what considerations should I take into account? Well, what considerations did you take into account in deciding to apply for crime?
For me, it was the areas I enjoyed studying most at university. So undergrad, the LLB, crime was the most interesting part for me. I took that in my third and fourth year and began specialising advanced criminal law. Then from that took many pupillages in both crime and family. I don't know if anyone practices family here, but I cannot imagine working in family. I did not like it at all. In crime, I did maybe 3 mini pupillages. I was in court every day. I was in the robing room with senior QCs and judges approaching me and discussing the cases, and I just found it a lot more welcoming, I guess, which is a strange way. But no, for me, it's just genuinely something I have an actual interest in. Be that from, again, enjoying it at university, reading crime novels when I was in high school. But no, I think once you find, again, everyone obviously on the panel here is a lot more senior than I am, but for me, it just clicked. My chambers purely practices crime and regulatory, and we're the only set in Wales that does that. So for me, it was a good fit. Again, after my second six, might be a different, I might have a different idea and might seek out a third six, as Laura was saying. It's always a good idea to have that in mind. But no, I've not sat in chambers once. 9 till 5:30, I'm in court. If we've got time between mentions, we're in the robing room or in a conference room. And that's really why I went to the bar, because it's just like Laura was and Kate was saying, it's a really fun area to practice. The stories that you hear are just a little bit, you can't be prepared for them, shall we say. Yeah.
Fair enough. Well, Ben, if I frame that more in the context of actual application forms, people are asking what sets an application apart. Well, when it comes to applying to your chambers, which I know is a very large chambers with a broad range of specialist practice areas, what do you want to see from people when they're saying, I want to apply for crime, I want to apply for personal injury? What's on an application form that makes you think, yeah, this person really gets it?
Well, we've relatively recently converted to specialist pupillages now. So although, in theory, it's no doubt right that people could, once established and a tenant of chambers, move across practice areas. Generally, the expectation is that if they apply for a particular pupillage, it's because they've got an interest in that area: family, crime, PI, employment, commercial. And so we do look for them to demonstrate some sort of commitment and reason for making that particular application. But I don't think we're unrealistic in that we, expected them to have only ever wanted to have practiced in employment law and that to have been their dream, forever. We're much more looking for people who we think would be a good fit, would be a good barrister, will continue to want to practice at St Philip's in Birmingham. So we don't, on the one hand, there will be an expectation that people can, in interview, explain why that practice area as opposed to another, but it's not something that we dwell on too much. The first round of our application process are, questions where people, have you ever been in this sort of situation in life? When have you had to persuade an audience who were against you? That sort of thing. So it's not based at all actually on on particular areas of law or anything like that.
Okay, that's great. That's really helpful to understand. Ruth, in terms of the sort of experience that you like to see people have, we often get questions about, well, mini pupillages, legal work experience. You're obviously looking at it from a specialist set. What sort of experience do you expect to see people have, or what's beneficial for people to have on their application forms?
Certainly don't expect any experience in the areas we specialise in. That's not what we're looking for. Mini pupillages, it's really, there's a cap, I would say, on the number you need. So would want to see 2 or 3 mini pupillages to show that you have a genuine interest in practicing as a barrister. But more than 3 doesn't really enhance your application. It might help you, the applicant, if you do 3 and you're still not sure which areas of law you'd like to practice in. But for me, looking at an application, I don't rate it more highly if you've got 12 minis versus if you've got 3 minis. It's really just, you need a couple to demonstrate genuine commitment to the bar. I am particularly impressed by achievements in mooting and debating. So if you've entered competitions and you've achieved first or second or some other award in mooting and debating, that counts a lot in my book. Some other quality legal experience, again, it's not about the quantity. You don't need to have done 5 different forms of legal experience, but if you've worked at a European court or assisted Citizens Advice Bureau or some sort of domestic refuge, something like that, where it for a fairly prolonged period, not just a week, but you've spent a month or so, at least a month, volunteering on an occasional basis, helping them, then that looks good. I would also say some achievement in competitive sport or competitive music, playing in an orchestra, that shows that you have a desire to compete, to attain grades, to excel in whatever your interest is. Anything else? And then we've also put a lot of weight on the quality of the cover letter. It's not the CV, sometimes you don't anticipate. The CV is just looked at very quickly because you have hundreds of applications. So a CV, you might only spend 3 minutes looking at a CV. We're not necessarily going to read all the detail. One other thing, sorry, I remembered on the CV, I like a bit of gritty work experience as well, been working in a bar, or something which shows you can actually handle speaking to regular people on the Clapham omnibus, and hard work, working at a restaurant, waitressing, things like that I often find more impressive than, oh, I was paralegal at a solicitor's firm, etc. Show a bit of real life experience, and then after that it really is the quality of the cover letter.
Yeah, I mean, I always think it's worth thinking about what you've done, thinking about what the attributes are for the type of barrister you want to be, depending what practice area you're in, and explaining very clearly to the reader what it is that you've done that shows that you've got the skills to do that job. Don't leave us guessing about why something's relevant. Just tell us. I mean, I think, Ross, were you going to add something there?
Yeah, I was just going to agree with what Ruth said. I was a cocktail bartender throughout my law degree and my bar course. Every single pupillage interview that I attended asked about it. I wasn't asked once about a mini pupillage, sorry. They wanted to know what it was like studying and working long hours. Every interview, sorry, would always ask some variation of the same question, which would be, if you were a cocktail, what kind of cocktail would you be? If you were to make me a cocktail, what would it be? And it gives you a really good opportunity to get rid of the nerves, because you have no idea what questions are coming up in the pupillage interview, but to give you 30 seconds to a minute to talk about something you actually know a lot about, because you've been doing that job for 6 months, a year. And in all honesty, I think my hospitality experience is what set me apart from other applicants.
Laura, can I just add in there? I absolutely agree with everything Ruth and Ross have said, but I do think that there'll be some people in the audience panicking because they're not in an orchestra or didn't particularly have the background in life that opens up to some of the experiences. And diversity is a really big deal at the bar. We are very open to the fact that people don't always come from a background which allowed you to have grade 8 in the piano or whatever it might be. So what is significant and what stands out doesn't have to be something spectacular in terms of, you know, Duke of Edinburgh. They're wonderful if you've got them, but there can be things in your own life, you know, people that are carers and that have managed to get really good grades or do really well whilst caring for a family member and things like that. And I always tell people there is pretty much no experience that you can't twist to show some strength that's required in a barrister. You know, if you've worked in Primark, you've dealt with angry people on a busy day. Well, you've got people skills, you know how to diffuse situations. There's literally nothing you can't pick the key skills for barrister and pick out of. So if you have got amazing qualifications and amazing, you know, awards, that's wonderful, and they make you stand out in your own way. But I don't want anyone sitting here thinking, well, I don't because of my start in life. It doesn't mean you're ruled out. It just means you've got to think more creatively, perhaps, about how to pick out those key features of the role and make them apply. And actually, I'm often more impressed by someone, as Ross says, who worked 3 jobs to pay their way through university. That's not to say that the people who didn't do that aren't excellent as well, but I'm more impressed by people who can show a bit of grit, and as Ruth says, and can show how they've ended up there, perhaps through their own determination. And I'm from Bolton, so if anyone says you can't make it from a less posh background, they're lying to you.
I think that's absolutely fundamental to convey, Kate. I mean, the most memorable and possibly best answer I ever read on an application form for pupillage in my chambers was work experience, milkman in Cumbria, delivering milk come rain, sleet or snow. Well, that's someone who's not going to complain about being sent to Carnarvon County Court tomorrow. You know, that's someone who's going to work hard. I get complimented by solicitors all the time on the detail of the notes that I take during hearings and how quickly I send them through to them. I worked in a call centre throughout university and learned how to touch type as a result. I didn't really realise at the time it'd be such a useful skill, but I probably wasn't back then, but it certainly is now. It's really useful. So I think Kate's right. Just think more creatively about it. Martin, does the same apply when you're looking for an employed role?
So the first thing I want to say is that, Ross, you can't possibly leave us dangling like that. You have to tell us what cocktail you would have been. I'm going to be totally mad if I don't find out. So the employed bar, really, it depends upon what type or what area of the employed bar you are going for. The employed bar isn't like the administrative law bar. It isn't like the criminal law bar. The employed bar is employed in that it does its work as an employed set of barristers rather than there being some mythical area of law known as employed bar law. So it entirely depends upon who you are applying for. My friend George Payne has a very similar practice to a self-employed barrister. It's just that he gets paid monthly and gets this amazing thing known as a pension and annual paid leave. That's very different from me, where I'm working in-house. So it really will depend upon who exactly you're applying for. If it's an in-house role, then most of the time they're going to be very keen to understand not just why you're interested in that area of law, but why you want to work with that particular company, that particular department, that particular agency, or that particular, in my case, government, although there's not that many governments in the UK, so you've basically got a choice of 5, and only one of them is the national one anyway. The process of doing that, I imagine, is very different if you are applying for a solicitor's firm that has employed counsel working inside it, in which case they'll be much more interested in the type of interview process which you would normally expect from a criminal set.
Right, now moving on to the absolute hardest question, certainly as applicants always find it to be. Ben, how do you answer the question of why do you want to be a barrister without sounding like a cliche?
Yeah, it's difficult, isn't it, not to sound like a cliche or a bit weird when you answer that question. I think you need to just think of the genuine, what actually brought you to the position where you are sat making that application or sat in that interview, and try and tell that story as best you can, rather than trying to think what are people supposed to say in this situation, and what do I think this person interviewing me wants to hear. You just need to think about yourself and your story, and when you do that, you'll no doubt have a genuine and good reason for wanting to be a barrister. Of course, you need then to map that on to the things that chambers are looking for you to demonstrate, and the qualities that we all know are required. But I think that that's where I would start.
Ross, you answered this question most recently, but Martin's quite right. I shouldn't let you get away without telling us which cocktail you would be and why.
So I took two approaches to this. The first one, I thought I'd try and, get my personality across a little bit, make a little joke. Silence entered that Zoom call that day. So I said an espresso martini because I'm full of caffeine and vodka. Didn't go down well. I got an offer for that set, which I don't know, but the rest of the approach was an old-fashioned, because it was the first cocktail that I made to enter into a hospitality competition, which I ended up winning. And again, that's something I kind of just snuck in there.
Nice.
Again, it's exactly what Kate was saying. There's nothing really that you've done in life that you can't tailor to being a barrister. And for me, that was late hours, long days, and memorizing a cocktail spec list of 150 to 200 cocktails, which again it's not particularly something that you might associate with a barrister, but these are things that, like I said, I was asked about at every interview.
Yeah, I'd never associate espresso martinis and barristers. But as recently as you've answered the question, why do you want to be a barrister? Can you remember what you said, Ross, and what you felt maybe worked and didn't work?
Yeah, it was a painstaking question because most sets ask it. And it took me a while to kind of formulate my answer. I broke it into two stages. My desire to be in self-employment, and the second part was my love and my enjoyment of advocacy. I did mooting all through my LLB. I was mooting president in my final year. I did, I don't know, some UK-wide mooting. In the bar course, I did a master's at Leeds Uni as well, in which I was involved in mooting. So I basically used that question to fit in other parts of my experience. And depending on the set, we might not ask you specific questions on advocacy. If it's a set that, I don't know, uses a cover letter, for example, you might not have specific room to answer or to get parts of your experience in. So that's kind of how I approached it. Basically answering the question how I wanted to answer it.
Yeah, I used to answer it as a sort of explaining it was an informed decision, looking at what work experience I'd had, what I'd studied at university, meeting, things like that I'd done, what bits of it I enjoyed, and therefore weighing all of it up, having done work experience at solicitors and in chambers, why I thought I'd be a good barrister and it's what I wanted to do. It's not the most interesting answer, but actually it was honest. Kate, what's your view when you see these sorts of answers? Are they ever really the groundbreaking question on the application form?
I mean, for me, how do you answer it without sounding cliche? You don't. Just accept that. Everyone says the same thing. Everyone wants to help people. Everyone wants to make a difference in the world. And I don't mean to be disparaging about that. It's true of the people we get, but the type of person who wants to become a barrister is a certain type of person generally. So what I would say is don't get bogged down too much and lose too much sleep about that and if it sounded cliche or not, because it will, but so will everyone else's answers to that question as well. And I've certainly never chosen a candidate or seen a candidate turned away on the back of that question, unless you turn around and say, because I want to be filthy rich and do no work, and unless your answer somehow suggests you don't have an insight into the role and what it requires. But generally, we're much more interested in you and your analysis and your skills, and to be frank, whether we get on with you, particularly when my set was smaller. It's harder now, it's bigger, but when my set was smaller, we take for granted if you've got a good degree that you know the law or at least can learn it. We take for granted if you've got a good enough bar course that you can learn the skills and we can teach you. We're not expecting a complete package. And one of my bugbears in pupillage application is the people that write about how they are the complete package. They're perfect at every stage already. I much prefer someone who says, look, I've got the foundation blocks, I've got the fundamental skills, which mean with the right support from experienced professionals, I think I can be good at this, than the people that go, I'm just amazing and I can do it all. So I just think, yeah, just don't get bogged down too much on the things like that. I'd much rather people showed who they were through other questions.
Yeah, I think that's really important. And when you're talking about those experiences to show why you are going to be good at this job and good for this set, but everything you tell us, just think to yourself, so what? Why am I telling Kate this in an application form for Park Square Barristers? So what? And just tell us, explain it to us. Ruth, do you expect different approaches from a specialist set in London compared to maybe a large common law or criminal set outside, would you think? Do you think you see different answers to the ones we might see outside of London?
You mean on that particular question? Why you?
Yeah, on that particular question, but if you think on any other ones as well.
Well, I agree with Kate. I don't think it's an answer which is going to win you the opportunity to have an interview, and I don't think much weight is placed on the answer by most sets. But two things I have seen which would give me or give some negative colour to my assessment. Firstly, a lot of people use the phrase relish the opportunity, and that that always sounds really hackneyed. So I would say avoid using that phrase when answering that question. The other thing I would say is if you're applying to a commercial set, don't say in your response to that question that you want to make a positive difference and change the world and you're interested in social justice, etc., because that just doesn't fit with what you do at the commercial bar. Equally, don't say I want to be filthy rich, but yeah, just tone down perhaps desire to change the world, that kind of rhetoric, if you're applying to the commercial bar.
Okay, great. Well, let's drill down into some more questions that we think might come up on the application forms. And there's a really good question here in the Q&A. When answering skills questions on an application form, such as please demonstrate how you've shown commitment, drive, analysis, etc., would you recommend giving lots of examples that show a breadth of experience or a single more detailed example in depth? Ben, what do you think's better when you're asking someone to show, perhaps tell us about two skills that you think a barrister requires that you've got? Do you want them to give the two skills in a list of things or a more detailed explanation?
First of all, I want them to fill the word count. It really bothers me. We have a 250 word limit on these questions and people write 100 words. And I think, well, how can you possibly think that you've been able to do everything, do yourself justice when you've used a fraction of the word count? But coming back to the question, I wouldn't provide a list because there's no benefit in doing so. You're not going to be able to convey anything. You need to select, I think, 2 or 3 examples depending on how much room you've got. You need enough room for each example to explain the context, the action and the result. And if you can do that, with a sufficient amount of detail whilst being concise, then and have room for 2-3 examples, then fine. If you can't do it, it would be better to have a single example rather than cramming in loads and loads, I think, but not really actually saying anything with each one as to what you did and the result and outcome of what you did and why you did it.
Kate, you've got a couple of judicial positions, and that sounds like the sort of question that we're now getting that would be on a JAC application, a Judicial Appointments Commission or Committee application. Tell us, what do you think about those sort of, tell us when you've done this, give us an example of skills. How best do you answer those questions?
The thing I see very regularly on pupillage applications is the people that don't answer the question. What they say is, I'm brilliant at, I don't know, dealing with confrontation, for example. I'm brilliant at dealing with confrontation. I do it all the time. I've done it in this job and I've done it in that job. Wonderful, but how do you do it? Because telling me you've done it lots doesn't tell me that you're experienced at it, and it doesn't tell me that you're good about it. So, I mean, in judicial applications now, and it's probably easier for people a lot younger than us, Laura, because it's something that's more modern and perhaps is drilled in more in university in a way that it wasn't in our day, which is the STAR approach: situation, task, action, and response. And if you use that as a background without necessarily writing it in such a formulaic way, you usually get how to spell it out. This is what happened. This is what I was supposed to be doing. This is what I did to resolve it, and this was what the outcome would be. I agree that if you've only got one example that doesn't take up all the space, it's probably not a good example. And if you look at the Judicial Appointments Commission, Laura, you'll know in there that they say bullet point if necessary. Now, I'm not saying necessarily bullet point in your application, but what that says to me, that if you're applying for the highest judicial positions in the land, they're happy with a summary of lots of things, then that can't be a bad approach to start with.
I guess it really depends on the question, and as Ben says, it depends on the word count, but I totally agree. I mean, it's not that I want to see you use lots of filler words just to get them in there, but someone who only puts a couple of lines in, it just feels as though you don't want it. They're the sort of ways that you show your commitment without you know, it's not what you say, it's what you don't say and the effort that it seems you have or haven't put in. That's why we get upset with typos. That's why we get upset when you reference the wrong practice areas or you misspell a member's name, for example, because that can be really quite frustrating. Martin, would you add anything to that?
Yeah, I was just wanting to add on these sort of skills-based issues. The trick really is in the name. You're not getting points because you ran a marathon. You're not being appointed to chambers or employed because you can run marathons. Why you are talking in your form about that time you ran a marathon was because it demonstrates that you were able to create a training plan for yourself, which you dedicated yourself to, which indicates that you have the stamina and the dedication that's necessary for your career at the bar. The fact that you chose to do that by running a marathon as opposed to learning a new foreign language or anything, ultimately it's the evidence which is fungible. It can change. What you're demonstrating is the skill. And that's the reason why ultimately the skill itself is the important thing. The demonstration is irrelevant insofar as what it actually is. It's how it demonstrates the skill.
And I think that ties us back into Ross's point about the bartending and identifying what skills you got from that. Okay, I'm going to pick up on a very practical question that I know is the sort of thing that makes people really paranoid. And there's a question in the Q&A, which is, we're asked for specific dates of when we were at university, when we completed our work experience, when we got our qualifications, and I don't know it to the exact day. Is it okay to give month and year? I've not got a problem with that. I don't know. Do anyone else on the panel disagree with me? Okay, there you go. If you've got your certificates and you want to put in the specifics, fine, but it's certainly not what I go to look at. What I would be interested in is, if you left university 10 years ago, what have you been doing since, and what skills have you developed in that time? How have you come to be at the bar? But that just feeds back into everything that we've asked already. Okay, now I'm going to ask the thorny question. Academics, what university you went to, what grades you got, how much does it matter? And second point to that question, how much does a master's help? Kate, you've already unmuted yourself. Go for it.
I know, I'm excited. You can see me chomping at the bit. Look, I'm from Bolton. I went to a comprehensive, which was incredibly rough. And here I am, 34 years old, got my first judicial position at 31. It doesn't hold you back if you've got the right skills, the right experience, and the tenacity to get ahead. But let's be honest, it's all relative. There are some posh sets that work in very specific areas of law. Look at who's on the website. You know, if it's a chancery and commercial set in London and everyone on there who went to Oxbridge and you did not go to Oxbridge, realistically, are you the type of person, I don't necessarily think the institution matters, but are you the type of person that's going to be able to fit with them well? The thing that matters is the explanation for it. You know, personally, and this is just my personal view, it doesn't reflect my chamber's view, I'm always more impressed by someone who's had what is clearly a difficult path to do well than someone whose path appears to have been very straightforward. And that doesn't mean I discount the person who's had a straightforward path. My own path was fairly straightforward. I went to the University of Sheffield, I got a first-class degree, I went to bar school, and I got pupillage pretty much straight away. So it certainly has never held me back. I don't think anyone should be worried in this day and age. We are genuinely, as I said before, concerned at the bar at diversity, particularly retention of women and minority people from different ethnic minorities, that it will hold you back. But what you've got to do is sell yourself well and explain, as I said before, I'm sorry I bang on about it, but it's a real bugbear of mine, explain how actually the fact that your path was different from others doesn't make you a worse candidate, it just makes you a different candidate, and there's nothing wrong with being a different candidate. So no, in general terms, it doesn't matter where you went, unless you are applying for something very niche, very academic, very technical. In terms of grade, you've got to remember that the people reading the pupillage applications are people at the end of the day. They're not being paid to do it. It's probably Friday and they've had a rubbish week and their children are having a fight downstairs when they're doing it. If you get 400 applications per place, as we regularly do at my chambers, you have to cut somewhere. You have to cut somewhere that is objective. So if someone raises a query or a complaint about how you've done it, that you can justify it. So generally speaking, my chambers would have a scoring system, and whatever, say it was out of 3, I don't know, if you got a first, you might get 3 points. If you got a 2-1, you might get 2 points. Got a 2-2, you might get 1 point. So yes, it does make a difference. Not because you can't be a phenomenal barrister with a 2-2, not because you can't be successful with a 2-2, but because at the end of the day, the tired pair of eyes reading that application has to make a judgment call about how to narrow that pile of 400 down to the 6 or 10 that you're going to interview. So that doesn't mean if you've got a 2-2 that all hope is lost, but it does mean you might want to bump up your point score somewhere else. You might want to look at what experience you've got that counterbalances it. Personally, for me, I don't think a master's is that helpful unless there is a reason your academic attainment wasn't as good as you had expected it to be otherwise. If you had a really terrible time in your degree and you would have got a first but for your experiences or something, or if you had a really great time and you were just out, having a laugh and didn't really concentrate as much and you know that you're capable of better, then perhaps look at a master's, look at something like that will show that you can demonstrate that you have got a really good brain behind it and an academic ability. But in general terms, it's not the end of the world where you've been. It's not the end of the world what you've got. It's about the balanced overall picture, unless you are looking at something really niche and really specific. And I'd look to Martin that because I think the civil service and the government legal department have set minimums for things, but he'll know more about that than me.
So our process used to be that we only took people with 2-1s and above. That's now moved to taking any second class degree or above, and the GLD in its application process actually looks at applications blind without looking at your university. I have, frankly, for myself, this is a discussion which we still have inside the office, I'm not entirely sure as to how useful that is all of the time. I tend to think that some of the recruitment tests that we use are rather blunt instruments, and that the educational background that you've had, particularly informed by what you got as A-levels, and then the types of exams that you've seen at university, can be more useful context than otherwise having a cut-off where, oh, you only made 74 of our path from 75 on a relatively blunt test, therefore you're not getting invited to interview. So I think there are real questions that people can reasonably have about that. I think one of the interesting things to notice is that in the other areas of administrative law, when you're talking about some of your top flight sets, it really is very much, if you have somebody who had a starred first from Cambridge and then has done a master's in Harvard, it is going to be difficult to take somebody who does not have that type of stellar academic achievement, which I could be clear, I don't have, but trying therefore to suggest that I should get an interview to Blackstone to 11 kBW when I don't have that becomes more difficult, and you are facing an uphill battle to the extent that there are definitely some chambers that expect to see a master's or relevant work experience when you're right at that top of the bar with the types of chambers which are really not quite household names, but which are household names amongst us in the bar, the people particularly at the top of the commercial bar and at the top of the administrative law and human rights bar. And that's doubly so for the incredibly small international law bar, which is a really, really small and very discreet bit of the bar.
Yeah, I think that's right. And I think we've got to be frank and honest about this. But I think what we can also say is there is a drive for social mobility, but in particular areas of law, again, looking at what are the skills for that particular barrister, is it more academic than it is interpersonal or oral advocacy? Academics do matter. And so looking at what results the junior bar in that chambers have got, yes, where they've gone to chambers can, where they've gone to university can still matter for the reasons Martin's explained about the exams, etc. That's probably starting to matter less and less, but we know the academics are tough, but as Kate's explained, most chambers have those sorts of scoring systems, and other than the top ones, won't necessarily entirely prioritise academics. Ruth, you're in London, you're in a specialist set doing financial work. Tell us we're all wrong.
This is a question which has been of a lot of interest to me, and I've changed my approach personally on this question within the last few years. So we are a small specialist set in London. We're in the commercial bar, but at the lower end of it. We're no Blackstone or Maitland, but it is nonetheless a London commercial set. So the area of law we specialise in is highly technical, and our clients are mainly high street banks or top tier financial institutions who expect a high calibre of barrister academically. So that's the starting point. And I think historically I thought, well, I came from a state school and I got into Oxford. Why can't other applicants have shown or demonstrated the same trajectory? And I think historically I was a bit closed-minded in the way I assessed applications, and I did put more weight on the academic criterion. If somebody had gone to not just Oxbridge but one of the top tier universities, in our chambers it's fair to say most of us are Oxbridge graduates. But we do have a high proportion of state school people amongst us as well. In recent years, my approach has changed, and it's fair to say that other people's approach have also changed on the Pupillage committee. And we are not yet at the stage where we're blind to what university people have studied at, but we place a lot less weight on it than we did a few years ago. So we're still looking at academic attainment, what grades have you attained, but we're placing less weight now than we did previously on what university you went to.
That's really interesting to hear. Thanks, Ruth. I'm conscious of the time, but I want to pick up a few more questions because we've had so many come in. Ruth, I think this one probably only applies to your chambers. Covering letters. If there's no guidance as to what to put in the covering letter, what sort of things should applicants put in there?
The cover letter is crucially important, and I feel it's more important than the CV, especially now I've dropped my closed approach to which university someone's attended. So really this is the applicant's opportunity to demonstrate their advocacy at the stage before interview. How well can they persuade me that they genuinely want to come to Goth Square, and that they'd do well at our set. Written advocacy is increasingly important at the bar and in the areas which we specialise in. So I want to see that somebody can write clearly, concisely and persuasively. I don't want florid language in there. A lot of people do put in too many adjectives, and it needs to be quite clinical, but explain to me in a targeted way why you are interested in the areas which we specialise in. So the first role really is to identify our main practice areas, look at our website for more than 1 minute, and you will be able to identify our main practice areas, explain why you think you would be a good fit to practice in those areas. So, for instance, do you like statutory construction, or do you have some sort of experience which has pointed you to this direction, or do you feel you have the particular skills required to excel in these areas?
Okay, I'm going to answer a question myself and then just open it up as a slightly broader but hopefully punchy question with punchy answers from everyone, because I'd be interested to know. So the question is, will my application be disregarded if I haven't done a mini pupillage with that chambers? Only if they are assessed mini pupillages that you have to go through that process, and it will be made clear on a chamber's website if that's what's expected. It doesn't happen very often. It only happens with the very top commercial sets, is my understanding, and I'm sure anyone will correct me if I'm wrong. But the wider question that's also been asked is, will I get a pupillage if I haven't done a mini pupillage at all? And I'd like to hear everyone's views on that. Ben, if someone's not done any mini pupillages, and bearing in mind we're in the times of COVID, so it's not quite so easy, does that mean their application form goes straight in the bin?
No, not at all. There's just no scope for that to enter the marking process in a way that it would lead to that happening.
Ross, I'm guessing you're not going to disagree, so maybe you could tell us what's something else that maybe you thought to do during the times of COVID, or you've seen friends do during the times of COVID, to try and demonstrate legal work experience or interest working from home.
The way that I approached it, because I was moved back to rural Scotland at the time, just during the pandemic, so I had no way of actually furthering my CV. So I got involved in the inn as much as I possibly could. I applied basically applied for everything. I became the treasurer for the LISA committee. I sat on the EDI committee with yourself, Laura. I did mooting as well. So basically, I physically wasn't able to get work experience. So I got as much experience as I could for the inn. The inn is incredibly helpful. The education department is genuinely second to none. Everyone is so helpful. If you have any worries about things like that, I would definitely reach out. But that's the approach I took, and it worked really. I got pupillage before finishing the bar course, and a huge part of that was from the efforts of the education department.
Yeah. And LISA is the Lincoln's Inn Students Association. I think you're right, there's been a lot of opportunities online. Martin, you've seen some of those with debating and the like. Do you think that's a good way to try and fill the gap during the pandemic with the reduction in mini pupillages and the ability to get out there?
Yeah, I think it does. I think the pandemic is a good reason why you don't have mini pupillages. If we were in a sort of coming out of an ordinary period and there weren't mini pupillages on your CV, then I think come interview, a fair question would be, why haven't you done any mini pupillages? Because so many people do. But the answer to that is because of the pandemic, and everyone knows that. And so it is a question of how it is that you responded to the pandemic and still got legal styles of work experience. Debating and mooting, I think, are excellent for that, but then I'm involved in them, so frankly I would. But I think that they are some of the best examples that you can have of how you're able to use your advocacy experiences and your advocacy skills in a real training environment.
Kate, a couple of questions for you on this. As a criminal barrister, would you still expect to see somebody having done a mini pupillage in order to see what life at the criminal bar and in trial is like? And then secondly, sitting as a judge, or in your experience as a barrister, what's the opportunities for people to attend hearings virtually to observe? And do you think that's useful work experience?
I think personally in crime, the criminal court shut down. The year 2020, when first lockdown hit, I didn't do a criminal case for 9 months. I switched to sitting. So we would never penalise anybody for not being able to get an in-person mini pupillage, because frankly, students were not our priority. Our members were our priority, and keeping the chambers going and keeping people with food in their mouths. So I wouldn't look for that. What I would say is there's a difference between mini pupillages and legal work experience, full stop. And there's a question I answered on the Q&A where someone said, I don't have any legal work experience, will that be a problem? And my answer to that would be yes, because what we're looking for is someone who wants to be a lawyer. And how do you know you want to be a lawyer if you haven't got any legal work experience? It doesn't have to be a mini pupillage. And I sort of said it before, one of my huge bugbears is people that tell us that they've done a mini pupillage and now they're perfect at everything and they understand everything. We've all done mini pupillages. They are greater or lesser in quality and value, is what I'm going to diplomatically say. There are some where you get a really engaging person who you're with, who answers your questions, and you learn a lot. And there are some where you sit in a corner or do the filing or read a document that no one actually talks to you about. So for me, a mini pupillage, great if you've got it, it's really helpful, but I'm not going to lose sleep over someone that hasn't when we've been through the pandemic. What I want to see is why you want to do law, why you know you want to do it, and why you'd be good at it, and something that says you're committed. Because at the end of the day, and I don't mean from a money point of view, but chambers commit to you. You get a pupil supervisor who becomes, like, my pupil master's my work dad. Everyone calls him my work dad, and I like him more than my actual dad sometimes. So you're committing a lot to a person in terms of your time and your emotional, and you want them to invest in them and you want them to do well. So if you're picking someone who actually doesn't have the experience to know that this is right for them, and they come and then they leave, that's really hard for everyone, because personally you've invested in that person. So get some legal work experience, but think outside the box. And I say, before I became a coroner, I said this: people look at marshalling and they look at marshalling schemes. No one ever asks to marshal the coroner. There's bloody hundreds of coroners, and they're all in different local authority areas, and most of them will be hugely proud if someone asked to come and see what they were doing, or just go and sit in a coroner's court, because it's a public court and they're all still open. And coroners is the one unique area where they have to be open, because a coroner's court is not a court without a coroner sitting in it. It doesn't have the jurisdiction that others do. So go and sit in one, go and see something different. Because for me, when I'm looking at pupillage applications, anything that's a bit different, anything that makes you think, oh, I'd like to speak to that person, is something that stands out and something that makes me get interested in them. So yeah, look at just different options. It doesn't have to be you've done 12 mini pupillages and you've followed around. I mean, sometimes in Leeds Crown Court, it's a small court area, in terms of barristers involved, it's the same people. You see the same mini pupils. One day they're with you, and the next week they're at the next chambers down the road, and the next week they're at the next one down the road. And that's lovely, but they've not learned any more with that chambers than they had with my chambers or with the next one. So what else can you do? And citizens' advice was mentioned earlier. If your bar school does any sort of pro bono work or just anything a bit different. And I think now more than ever is the real open opportunity at the bar to sell something different, because previously it was more traditional and every candidate had a 2-1 and 2 mini pupillages and so on and so forth. But now with COVID, everyone's had to work completely differently for years. So now's the time to get something a bit quirky and a bit different and just sell yourself on it.
We've had some questions as well about how best to answer the more specific questions. I think in terms of why this chambers, really it goes with the why the barrister and the advice that we've given so far about doing your research and being honest and well informed. In terms of the sort of problem questions, something I wanted to raise because it's a bit of a bugbear, and it comes up both in applications and interviews. If we ask you to prepare a presentation or to answer a question or talk about something you're passionate about that's not legal, don't turn around and talk about something that's legal, especially if it's the specialist topic of someone in chambers. Don't talk to us about the CPR. Don't talk to us about specific areas of personal injury. It comes down to the fundamental issue that we have to do as barristers, which is sticking with the brief. Answer the questions that are being put to you. Following those instructions is absolutely fundamental. And I just wanted to get that out there in response to some of the questions that we've had. I don't know if anyone else has any sort of general guidance like that.
I'd just add into there, make sure you don't pick a topic that someone on the panel knows significantly more about you than you, because you're just setting yourself up to fail. If you pick a really niche area of Shakespearean literature and you happen to get the head of chambers who's got a PhD in Shakespearean literature, then you're in for a harder day than you thought. And for my coroner's interview, for example, they said exactly that. They said, we'll give you a presentation a week before you go on a topic. And I spent the first week absolutely terrified that it was going to be on a niche area of law that I didn't know anything about. And then when they sent it, it said, give us a talk on any topic you like, which is important to you. And that's even harder because you reveal so much more about yourself when you pick something that's important to you. And they told me after I got it that one person did a talk entitled 5 Lessons I've Learned from Being a Coroner Somewhere Else, which they immediately discounted because it didn't answer the question. I gave a topic on breastfeeding peer support because I run a breastfeeding peer support website and it's something I'm very passionate about. I took the view that there were unlikely to be anyone on the panel who knew more about it than me, unless they were also someone very committed to that area of support, in which case I might have an automatic win and someone on my side for doing it. It's got zero relevance to coroner, but the question was what's important to you, and that was the answer.
Yeah, absolutely. Martin, are you reaching for the unmute button there to add something?
Just don't fake it. You have the whole of your life experience to pick. There should be something outside of the law which excites you, both because one, that should indicate that you're a better human being, and two, frankly, you have zero chance of surviving through a career in the profession if you don't have something else that you can occasionally look at which gives you a break from being a lawyer. So hopefully there should be something which you can think about, say, oh, I'm really interested in that, I'm passionate about that, and then just don't fake it, because the circumstances when you get this description, and often you will find that there's someone on the panel who has some form of approach like to it or knows a little bit about it and wants to discuss about it. So that's the way that barristers are, and it will come across if you're not actually being truthful. So it could be about tiddlywinks. I really don't care, but it just needs to be true.
One of the best interviews I ever had was when I'd mentioned that I was interested in hiking, particularly in Snowdonia, and someone in the panel said, oh, you'll know Pete's Eats then. And I said, Pete's Eats? I'm not a Pete's Eats girl. I go to the Pinnacle Cafe. And they're just corresponding cafes on either side of Snowdon that if you said you like hiking in Snowdonia, you would know about. And if you didn't, you'd be found out pretty quickly. And we built a great rapport from there. Now, you can't account for having someone on the panel like that. But, you know, all you can do is be honest and hope for the best. Right, I'm going to conclude with a couple more points where I'd just like the panelists to give some examples, because we've given you the guidance, but sometimes just giving you actual examples can help people to jog their memories. We've heard Ross was always asked about being a bartender. Was there anything that you were always asked about? And I'll explain. For me, it was the fact that I'd been an army cadet to a fairly high level, and I'd worked for an MP during my summer holidays. That's what I was always asked about, way beyond anything from my 2-1 from Liverpool and my very competent from MMU and my pro bono, etc. Those are the two things. Ruth, how about you?
It's a very long time ago now, only in 2005 I was interviewing. But I think I do remember I'd put down which subjects I'd specialised in as part of my degree, and I kept getting asked about Aristotle's Nicomachean Ethics. I couldn't remember any of it because I have a very short-term memory. It's like a sieve. You know, I accumulate knowledge quickly, but then dispense of it once it's no longer useful. So I'd say anything you reference on your CV, just be, if it's referenced on your application, just be on alert that you might be asked about it.
Ben, how about you? Is there anything that you had that you thought people were particularly interested in, or that you've seen on recent applications that you thought, gosh, yeah, I've got to go and ask about that?
I really can't remember. I don't know if it's because it's so long ago and I didn't make it to enough second rounds where the conversation opened up that much, and I was sort of dealing with those preliminary, quite rigid interviews initially. You know, and I'm struggling with specific examples in recent years interviewing people, but I can say that, you know, we will always, in later rounds, if there's something quirky, interesting about them, that's what they will be asked about. It will pique people's interests, and it's good to have that hook within your application because it immediately engages it engages everybody and provides that sort of basis for the rest of the interview, and it obviously puts the interviewee at ease, being able to speak about something that they know about. So it's a very useful thing if you've got something that you can talk about that's a bit different and a bit quirky.
And Martin, how about you? Was there anything quirky that you were asked about?
You've started the process of re-traumatizing me by reminding me about when I was asked what the most recent book was that I had read. And it was the most horrible piece of trashy sci-fi which I had read to de-stress on the tube going to the interview. And so I had to quickly think about actually talking about some of the more highbrow reading that I'd done recently, because there was no way that I was missing having read something about Warhammer 40k in front of a load of barristers. That would have been too much. But the other thing I was asked about was you still do put on my CV about being a young leader and having been a Queen Scout when I was a teenager. Still don't anymore. It's been a while since I've looked at my CV, but it was certainly on there. And I was asked about the leadership skills that I gained doing that, and about the time when we were canoeing down and one of the canoes capsized and the tents were slowly floating away and were difficult then to find, and about how we stayed warm that night, which I somehow managed to make relevant about what it was that a lawyer would need to do in those circumstances. There's always some way in which it is.
Yeah, that sounds actually not dissimilar to some of the things I talked about. Kate, was there anything in particular on your application?
No, I mean, I had 2 interviews and got my second one, so I'm probably not the best person to ask about that. But I'll tell you what I do remember very clearly, which is the first one I had was a posh London set, which frankly would never have been right for me. And I can look back now and say that, obviously. I wouldn't have been happy there. They wouldn't have been happy with me there. And I gave the answers that I thought they wanted to hear. And it obviously didn't work, and it didn't come across well, and I never heard from them again. When I got my interview in Leeds at number 6, I did bar school with you in Manchester, and what we were told on the Northern Circuit was don't go anywhere near the Northeastern Circuit. They're very insular. They only want people with a really strong connection with Leeds. If you've not got that connection, they won't touch you with the barge pole. So I applied on a whim to a pupillage that was advertised. It was outside of the normal process, the old pass as it was then, the pupillage portal. And I applied thinking, well, I don't stand a chance because I've got no connection to Leeds. I think I've been to Leeds once in my life. And when I got to interview, they asked a question, and this shows my age, but it was when Scotland had released the Libyan bomber, and America was very cross about it. And we had to do there was 3 parts of the interview. The first one, you had to argue why Scotland was right to do it. The second one, you had to argue why Scotland was wrong to do it. And the third one, you had to argue them both back to back to see if you could switch from the one argument to the other. And after I'd done whatever argument it was, someone who is now a very good friend of mine in Chambers, very senior, said to me, well, what do you think is the most compelling argument? And I said, that this is for why Scotland was right to do it. And I said, because it really annoyed America. Now, at the time, those young ones of you won't remember, but the America had a big thing about their health service at the time. And they were running a campaign about how terrible the NHS and socialised medicine was. And the whole country was up in arms about it, because obviously we all love the NHS. And it was sort of very much, who are they to criticise this? And I said, yeah, because it really annoyed the Americans at a time when they were really annoying us about something else. And that was what I genuinely thought. I'm not saying that's an advisable answer, but I told the truth instead of saying what I thought they wanted to hear, which presumably would have been about the strict application of jurisprudence and how they'd applied the principles. And he laughed. And at that point, he said, I knew I'd get on with you. And that's what I wanted to know. So just be yourself. And I know that's such a trite thing to say, and it's impossible when you're terrified and it's your whole hopes and your whole dreams on the line. It's impossible to be yourself. But if you answer what you think they're looking for, you will inevitably get it wrong, because you don't know what they're looking for. And if you say something and they don't like, then it's probably not the right place for you anyway.
That's a great answer. And just finally then, we've stuck really with pupillage applications because we know that's the stage that you're at the moment. And we know, there'll be general advice around about interviews and the like, and a lot of what we said about being honest and being yourself, albeit the best version of yourself, applies. But there's a final question that's been asked, and I think only Ben might be in a position to answer this. We've been asked, will the interviews be in person, or will there be a choice for them to be conducted online this year? Do you know if that's something your Chambers has considered yet? I'm not aware at the moment.
I don't know that a decision has been made yet. Last year's, which I took part in, were remote, and I know that I would want them to be in person if they can be in person. And I would hope that they can be this year, but I don't think any decision has been made yet.
Great. Okay. Well, I'm sure that's plenty long enough for me to be able to keep our excellent panelists this evening on a Monday night in January. Thank you to the 136 of you that have stayed with us for this full hour and 20 minutes. We hope you found this useful. I'm told this is being recorded, so if you want to re-watch it or ask any of your or send it on to any of your colleagues, then you should be able to. Apologies to those that we haven't managed to get round to answer your questions, and thank you so much to the panelists that have been doing that in the Q&A typed function as well as we've been going along. Best of luck to everybody, and just remember, we read your application forms because we want to find good barristers. We want to help you. We sit on interview panels because we want to find good barristers. We're not there to scare you. We're not there to be horrible. We are there because we actually want to be, and we're interested in finding the next barristers that are going to be up here on the panel with us. Alice, handing back to you.
Yeah, no, that's it. So I'll email out the recording and post it on the website. And a massive thank you to all of you for coming. And I hope it answers some questions. So thank you.
Thanks very much. Good evening, all.
Goodbye.